So earlier this week, the Western Cape High Court dismissed suspended Public Protector Busisiwe Mkhwebane's bid to interdict the impeachment inquiry against her. Parliament's Committee for the Section 194 inquiry met this week to plot a way forward. For more on what transpired from that meeting, we're joined by committee co-chairperson Qubudile Dyantyi. Thank you very much, sir, for availing yourself this afternoon. Let's just start with maybe a debrief in terms of what was discussed in the meeting and some of the key takeaways.
Thank you and good afternoon, Dudu and your viewers at Newzroom. We did two things on Friday when we met as a committee. One, we were taking stock of progress that has been made since our last meeting, which includes the submissions that the public made when we invited them to make a submission on whether to exonerate, whether they have information that will help exonerate the public protector, or they have information that will assist us to find concrete findings that she's not fit to hold office. We also took stock and gave an update on the opportunity we gave the public protector, which we call the Audi process, where we said we gave her a month to also present whatever that she feels she needs to place in front of the committee, including her telling us who her legal representatives are. But also we used the opportunity to get an update of the litigation processes. And at that point when we met, we were able to get it fresh that firstly a day before that the public protector would have been suspended. And in the morning of Friday, the Western Cape High Court dismissed all of her prayers. So that's the first issue we're focused on. But the second one, and most importantly, we were preparing for the critical July milestones. And I make an emphasis, July milestones, because July is going to be very hectic, because this is when we're going to start actual hearings with all the witnesses that would have identified, including herself as a public protector coming in front of the committee for the actual hearings. And this is important because at that point, Parliament would be in recess. So we're preparing members of this committee to say, we actually don't have a recess. We're going to have to work throughout, because we have a deadline of September that we don't want to miss. By September, we want to have finished with our work.
So then, Mr. Dyantyi, this suggests that her suspension by the President on Thursday has no bearing on the work of the committee, since you are chasing these deadlines in July and in September, just to reiterate.
Yes, indeed. And we've always been clear, Dudu, that whether she's suspended or not suspended, it had nothing to do with our work. This is a prerogative of the President in terms of Section 194(3) subsection A. Whether she was or not suspended, we're going to continue with our work. While she's eventually suspended, it might assist our work or might not assist, but we were always unfazed and focused on continuing with our work.
I'd like to pick up on one of the agenda items which you indicate is the submissions that were made from the public on whether for her to retain her job or whether to be let go. Are you able to talk us through some of those submissions? What did the public have to say?
You remember the closing date was the 3rd of June. So last Friday, it would have been a week since we have received those. And so far, by that date, we have received 24 submissions. 11 of those, what you call substantive submissions, where they were done under oath, with a number of witnesses giving us documentation in that regard. And the rest would have been people who just gave us information about their own views about what they think should happen, whether she must be exonerated or she must just be removed from office. At this stage, I'm not going to get much deeper into the actual names of witnesses or the actual documentation. We're likely to give you more as we prepare for July, before we call all the witnesses.
Fair enough. But are you able to tell us whether these 11 substantive submissions, those people, will they then form part of the witness list?
Indeed, we'll consider all of them, Juju.
Thank you very much for that. So when you talk about starting the hearings with witnesses, for those who may decide along the line to change their minds, do you see yourselves, taking a legal route and actually going to the courts to press them to show up and make themselves available for this process?
Part of what also did on Friday, which I left out, was we also took a decision that myself as a chairperson would have been given the powers of summoning those who would not come voluntarily when we need them to come to the committee. So all systems are in place. If there are going to be witnesses that we think are going to help this process, but they are reluctant to come forward, we will summon them.
Just looking at the July and September deadlines, the hearings are likely to start in the first week of July. Please, could you confirm that for us? And in terms of the September deadline, are you given the last day of September to then submit the report?
Well, we actually have a date for the first hearings. It is the 11th of July. That's the date we have in our roadmap. And our plan is that at the end of September, the country would have known what the outcome is in terms of the inquiry that we're going to go through. And we stay in focus because we want to only be influenced by facts and evidence in front of us. It's serious work. It's a pioneering work in the context of such institutions as the Public Protector. It's never been done before, and we want to make sure that it becomes an important and credible reference point.
Let's pick up on that point. You rightfully say that this is precedent-setting. It's serious and pioneering work. In terms of the committee itself, are you satisfied, or are your principals satisfied that the people who will be sitting on this committee have been vetted, particularly when it comes to this is something that has divided opinion in the country, where you have people who say, well, she should keep her job, and those who say, well, she should go, that you are sitting with members of the committee that are completely dedicated to this process and will not be biased in any way?
Yes, I realized on Friday, and I've always known that my work as a chairperson is going to be very important in navigating, in guiding the committee, because this is a constitutional process, a political process, and it's made up of a representative from political parties. But what we emphasize is that once you're in this committee, we don't necessarily want to take issue with your position, but you will have to probe here what are the facts in front of you, because there are political parties that are part of this committee who have already said she must be exonerated. They've gone to court in that regard. I cannot, in leading this committee, have a particular negative attitude, because that's a view they carry. But when it comes to the work of the committee, it's only the facts and evidence that must influence us. You'd have another extreme of those, and I refer to this as a briefcase outcome, that I don't want members who come here with a briefcase outcome that they already know that she must be removed. And let us allow what is in front of us to dictate the outcome of that. So I welcome all of that. It's a melting pot. There's a lot of diversity of views and understanding and reasoning, but it's an inquiry. Because remember, this inquiry has got twin possibilities. We're either going to exonerate her, or we're going to find that she has indeed committed misconduct, or she is indeed incompetent. Any of those, and therefore there is no middle road. There's no black or gray. It's either going to be one of those two outcomes.
What will you be using, I guess, for the inquiry, Mr. Dyantyi, in terms of finding the facts and finding the correct information in order to come to a conclusion? I guess, what will you be, marking the evidence that you will be hearing against?
We have designed this as a hybrid process. It is a committee-led, in other words, member-led. It's led by members of parliament, because that's our constitutional responsibility. But we've also, to include the hybrid, have designed it in such a way that we have evidence leader. And we have two of those, advocate, senior counsel Nazrin Bauer, together with the advocate Misa Mayosi, who have been at work in the last month or so, gathering that evidence, making sense of that. And so when we start with our witnesses, we will be ready with that evidence and distilling the kind of information. So I'm very excited about this process, challenging as it is.
Very quickly for us, sir, since it is hybrid as well, are there any witnesses that want to remain anonymous?
At this stage, they have not indicated as such. I think there seems to be a lot of excitement and people willing to put their feet forward to whether they bring reasons for exonerating her or reasons why they feel we should make findings against her.
Co-chairperson for the Ad Hoc Committee on Section 194, Qubudile Dyantyi. Thank you very much for your time this afternoon.